Hello, my name is Chris Young. I know many of you. I see many familiar faces. Just a show of hands, how many of you are familiar with special needs planning in some way? Okay. And the rest of you just are interested in learning more about it or think it might impact you or a family member? Is that okay? Very good. So one of the things I want to do is just make sure that you feel comfortable asking any questions you might have. Go ahead and raise your hands. I want to make sure that we leave here with more knowledge than we started with. This is a very dense area of the law. So I will go pretty quickly, but will also offer the opportunity. My cards are on the table on the back. And if you email me afterwards and ask for a copy of the slides, I can send you a PDF so you can review those later on your own time. Okay? A little about my firm. I'm with the Alvarez firm. These are the areas of law that I focus on. Primarily today, we're looking at elder law and special needs planning, but these are other things that I do as well. And my firm focuses on business and real estate law as well. We have offices here in Camarillo, Calabasas, and in San Juan Capistrano. Some attorneys go to the extra step of becoming specialists in this area. So I'm certified by the State Bar as a specialist in this area of law. And I do recommend, especially with special needs planning, that you make sure you work with somebody that really does know what they're doing. For some reason, my peers in the Southern California have selected me as a super lawyer. For whatever that's worth, I put that on there as well. And then many of you know me already, but these are a little bit about me and just my background and things that are of interest with my family and whatnot. If you've ever listened to the soundtrack of the Civil War series that Ken Burns did, you know the kind of music I've been playing that since I was 4. That's where I'm from, Portland, Oregon. And I moved here almost 13 years ago because of that lovely lady there in the middle. That's the young family. Her name is Sarah. And there's a pop quiz on that at the end. All right, so a lot of people ask about elder law and how it differs from estate planning. The main thing that elder law does is focuses on incapacity. What happens when you reach a point, or somebody that you love reaches a point of not being able to do things on their own, versus what happens to my stuff when I die, which is the typical thing people think of when they do estate planning. So elder law focuses very much on the incapacity planning more than most attorneys, more than most estate planning attorneys. We also focus on special needs, protective proceedings, so court proceeding to protect someone. That's typically in the form of a conservatorship. And then elder abuse prevention and remedies also rounds out elder law. And that's in and of itself a very specialized area that a lot of attorneys focus on solely. So to understand special needs planning, one really has to understand public benefits. And what's the point of special needs planning? For many people, it is about, first and foremost, and it's not the entire thing, but first and foremost about protecting and preserving the public benefits that a particular disabled individual is entitled to, not making them involuntarily ineligible. So this is heady stuff, but I recommend that we take at least a 10,000-foot level look at public benefits and understanding what we're talking about here. So the topics I want to talk about today are when are special needs trusts used, the basics of public disability benefits and preserving eligibility, different types of special needs trusts, and we'll talk about those, and any alternatives that may exist, and then common mistakes to avoid when implementing special needs planning. So that's a lot of material to cover. But why do we need to do this? Well, currently 1 in 7 in our population meets the definition of disability, of disabled. We have aging baby boomers. The population over 65, the percentage or the proportion of the population continues to grow that's over 65. Interestingly, the over 65 population tends to drop in numbers of actual disability because of advances in medicine. All right, but conversely, younger population is continuing to become more and more disabled. And the common conditions that we see are These are conditions that will make someone eligible for supplemental security income, which is SSI. We'll talk more about that in a minute. But with the doctor's diagnosis and certain conditions, asthma, autism, childhood obesity, these are all things that can render someone disabled under the law and qualify them for certain benefits. So the numbers of disabled people continue to rise, even though the older folks are getting better medicine, and it's a less common, or it's less, the growth is less in the over 65 group. So we consider special needs trusts when any of these things, or special needs planning, when any of these things is true. And for many families, it's multiple, it's some or all of these 8 items here. We want to provide financial security for a loved one with a disability, preserve their means-tested public benefits. We'll talk about what means-tested means in a moment. Select an appropriate team to assist with their lifetime management, ongoing system for advocacy for them. Once the parents or the support system passes on, who's going to advocate for this individual? Planning for their caregiving needs, coordinating the entire extended family's planning. So how does the disability or special needs planning fit into the overall estate plan? Protecting that beneficiary from predators, which is a real issue, and then preserving assets for other heirs. And that's where knowing and understanding special needs planning can really make a difference. Do all people with disabilities require special needs planning? There's actually a word missing. It should say special needs planning at the top. The answer is no. The key is, do they receive a means-tested, will they now, or are they eligible in the future to receive a means-tested public benefit? Means-tested means it's based on my income and assets. What do I have, and can coming into money impact my eligibility later on? So, and we'll learn more about why this is, but SSDI and Medicare are examples of public benefits that are not means tested. Those are entitlements, okay? So a lot of people are confused about Medi-Cal versus Medicare, and it didn't help that they're so closely, they sound so similar, but they're very different programs. And then SSI and SSDI, same problem, very similarly named, but 2 very different benefits. These are run, Medicare and Medicaid, which is what California Medi-Cal is. It's Medicaid, is run through the Centers for Medicare and Medicaid Services, CMS. And SSI and SSDI are run through the Social Security Administration. So these are the 2 federal programs that oversee all of these benefits. Here is a chart that shows, in very quick visual summary, of what programs are needs-based versus entitlements. And what do I mean by entitlements? Regardless of your income or assets, you are entitled to SSDI if you qualify with a disability, and Medicare once you hit 65. Warren Buffett is on Medicare. Okay, so everybody who hits that age and a U.S. citizen meets the requirements, they paid into the system, they are entitled to the programs in the middle. But needs-based are those that are on the left there, SSI, Medi-Cal, and more recently in California, expanded Medi-Cal, which covers a greater portion of the population. Frankly, all adults, more or less all adults in California now, as of this year, are eligible for Medi-Cal under certain conditions. All right? But we want to focus on SSI for the moment, because SSI is really where the rubber meets the road when it comes to special needs planning. There is so much that can be done for people that are outside of SSI, but if they are relying on SSI income, they need to really, and their families and their parents and grandparents really need to be thinking about special needs planning. So what is SSI? It is supplemental security income. It is welfare run through the Social Security Administration, and it's cash for food or shelter to disabled, blind, or aged, anybody over 65, individuals, okay? The federal benefit amount this year is that $943 that you see on the left. In California, we supplement it with an additional about $240. So the benefit amount in California this year is the 1182.94 that you see on the right. How are you eligible for SSI? There are two primary tests. You must be poor and you must be medically disabled. All right, physically or mentally, or under the SSI's definition of elderly, which is 65 plus. All right, now how do we know whether we're poor? So we look at a resource test and an income test. All right, the resource test looks to see what money you have available to you. All right, and certain assets are exempt, but when we think about cash first, you can have $2,000. I don't think that number's been updated in the last about 40 years, 30 to 40 years, but that's the number, $2,000 in cash or liquid benefits that are not exempt. If you're a married couple and on SSI, $3,000. It's measured as of the first day of the calendar month. It's 12:01 a.m., April 1, May 1, that's what we look at. So if you come into additional income and then spend it in a given month, that may impact how much you get, but it doesn't impact your resource test. What are some of those exempt assets? Here's a list. This is not all inclusive, but it gives you an idea of the types of things. You can have a car, you can have a house, your personal effects, your collections, your musical instruments. There's burial insurance and life insurance policies with cash value of less than $1,500. All of these there's a lot of detail to these and a lot of fine print, but these are exempt assets that a person on SSI can have in addition to that $2,000 cash limit and still qualify. In addition, we look at income. So there's four main categories of income. There's unearned income, okay, passive income, that's money given to you or earned on investments. Earned income, a lot of people, if we go to Vons or Ralph's or any of these stores, you see disabled people who are working. They're collecting cars, they're helping with bagging, they're doing things around the store. Those people are probably on SSI, and they're probably having their income impact their SSI benefit, but income is a good thing. Having a job is a good thing. It gives us fulfillment, right? So it's okay. We just have to understand what the rules are. It's very hard to read there at the bottom, but it says there, right where I just pointed, it says that earned income reduces your benefit $1 for every $2 earned after $65. Okay, we just know the rules. We don't ask why because these numbers seem rather arbitrary, but $65 is disregarded. And after that, if somebody earned $500 in a given month, they would see they'd see a $250 reduction. So $1 reduction for every $2 earned. Okay?
Is there a limit what they can make up to before they cut the SSI?
The extent of their benefit. So if they receive, when we talked about that $1,184 or $94, obviously if they earn more than about $2,000, it's going to impact it completely. And there's reasons why they might not want to do that. For instance, the simplest way to qualify for Medi-Cal, simplest way in California, is to be on SSI. You are categorically eligible for Medi-Cal if you are on SSI. So it's important to keep some SSI benefit coming in. But this is something that parents can sit down and say, okay, work this many hours and don't earn over this amount. And so having the knowledge is what's the most important. There are two other types of income. These are also very important. In-kind support and maintenance. We're going to talk about that more. But this is the answer to the question, what if the person at SSI lives at home with their family and they're getting food and shelter? All right. Well, SSI is there to provide food and shelter. You saw that on an earlier slide. So what does Social Security say about that? They say we reduce the amount of income that you receive from SSI up to for the amount that you receive from your parents or whoever you're living with, up to a maximum of 1/3 of the federal benefit amount. So remember, the federal benefit was around $900, a little over $900. So about $300 is taken away. You'll see a lot of people with $800 and some dollars a month in SSI. Why? Because they're living at home. They've had their benefit reduced because they're living at home, but they're still able to stay on SSI. So the good news is that they only reduce it by up to a third. Okay? For many, many people, the benefit they're receiving from living at home with their family is far excess of $300. But they don't count anything beyond that. 1/3 of the federal benefit amount goes away. Yes?
Back to the asset part. If an individual receives, for instance, a settlement, let's say car accident, medical, whatever, is that considered that amount an asset?
So, great question, Kevin. Is money received from a settlement or some amount that's passive income, right? So that is looked at as income in the month received. The question is, does it become a resource? And the answer is, if you don't do something with it in the month you receive it, and at that snapshot, the beginning of the next month, you have more than the $2,000, your benefits are impacted. The last category I want you to look at is deemed income. So these are the 4 categories of income that Social Security Administration has. Deemed income is a parent or a spouse's income is deemed to belong to the disabled beneficiary. That's why nobody under 18 is on SSI, because they may be on some other benefit, but in very rare situations would they be on SSI because the parent's income is deemed to be theirs. The parent has a duty to support them. All right. So we look at deemed income as well. So I can go into more detail, but let me just point out a couple of things. The first $20 of any income that you receive is exempt for any purpose. So you can hand somebody on SSI $20 a month, and they don't have to report anything to the Social Security Administration. Remember I said $65 of earned income. So really, it's $85 for somebody that's working a job. It's $85 that's disregarded because they get the benefit of that general exemption of $20 plus $65 for earned income. All right? So I won't get too much into the weeds on these other than to mention them. These are the rules for unearned income. Also, $20 is disregarded. And it's a dollar for dollar reduction. So if you hand them $100, they get $20 disregarded, and they get an $80 reduction in their benefit. This is the rule. These are the rules. Many people don't know the rules, but it's important to understand what's going on there, okay? There's ways around this that are completely legal, and we're going to talk about them. So real quick, let's talk about that in-kind support and maintenance that we talked about. So if somebody receives from mom or dad or a relative these items, those count against you, but remember, it's a maximum of 1/3 of the federal benefit amount. So, but just know that this is what in-kind support and maintenance is. And I threw an example in there. This fellow lives with his brother, gets 3 meals a day, and doesn't pay rent to his brother. And so, because of that, in California, using the current numbers, his benefit goes to $873.87. There's about that little over $300 reduction in his benefit, okay? So if you see somebody walking around that has, or if someone in your family has $873 or right about that as their SSI benefit right now, it's because the Social Security Administration is reducing their benefit due to in-kind support and maintenance. Very, very common. Now, a lot of people may ask, can I just give away the money I got? I got a settlement, I got an inheritance, can I give it away? Well, the bad news is the Social Security Administration has thought of that one, and they have rules about that as well. It is a dollar for dollar reduction in your benefit for anything that you gift, that's your assets, that you gift to someone else. But there's a cap. 36 months of benefit is the maximum amount that you can lose. So here's an example. Eric receives $875 a month in SSI. He gets an inheritance from his mother of $25,000. We have to divide that $25,000 by his monthly benefit of $875, and that turns into little over a 28 and a half month loss of his benefits. So Social Security, SSI, would stop his benefits for 29 months, almost 3 years.
And you're supposed to live off of $800 a month.
No, you're supposed to live off the 25,000 during that time. You don't get the 800. They stop the benefits. Yep. So again, keep in mind this 36 months. This is a good thing because if Eric lost or received 50,000 from his mother, the most he's going to, and he gave it to his brother, the most he loses is 36 months. So I didn't throw another example in there, but you can do the math. 36 months of lost benefit is the maximum, regardless of how much he gave to his brother. But there's another issue there that I'm not touching on, and that is why would we want to give our inheritance away? Is there another option? And that's where special needs planning can come in. And then you may be asking yourself, well, how will the Social Security Administration ever find out any of this stuff that you're talking about, Young? And the answer is, we have a duty, if we're receiving these benefits, to self-report by the 10th of the month following the change in circumstance. So if I get my inheritance in April, by May 10th, I have to tell the Social Security Administration what happened. I have to tell them these things: what my number is, the facts about the change, and when the change happened. Okay? Does that happen all the time? I am positive it doesn't. But I want to chalk that up to a lack of understanding of the rules. It's not a good idea not to do this. It's a good idea to understand the rules and to make sure we play within those rules, but not to disregard this reporting requirement. I want to quickly touch on Medi-Cal. This used to be a lot longer section, but the good news is, as of January 1st of this year, everybody gets Medi-Cal. All right, there's no asset limit. All right, so, and remember I said you're categorically eligible if you have $1 of SSI. So, but it's free Medi-Cal without an asset test for all adults as of January 1st of this year. Now, there's a lot of other things that come into the equation, but just know that. So Medi-Cal is not the burden that it once was to receive. But there's a big but here. Watch out for recovery. We care about how much Medi-Cal pays for us because that comes into the equation when we die. How much do we have to give back to the state for what they've paid for us? And sometimes it can be quite a lot, okay? So eligibility, when you think about Medi-Cal, we think of two things. We think of eligibility and we think of recovery. What does the state get back when I die? And we want to preserve eligibility, and because we all would prefer our assets go to family members, I think that's a safe bet, or our friends. We try to reduce the amount that goes back to the state, and we want to give it to other people if we can, right? If we can't, then there's nothing we can do about it. But we try to do that. At least we plan for that, okay? I'm going to really quickly just say that SSDI, remember I said those are entitlements? We don't have to spend a ton of time. I just want to mention that if you've paid into the system, if you've worked 40 quarters, all right, which is 10 years in your life, and paid your payroll tax, then you're eligible for SSDI if you become disabled. And anybody who's seen that quarterly statement they used to mail out, but now you have to go online to get it, the Social Security statement, it tells you exactly how much you'll receive if you become disabled before age 65. And if you're over 65, they'll tell you how much you get in retirement income, or whenever you take it, 62 to 70, or whenever it is that you decide to take that income. Okay? If you're receiving SSDI, and this is a really important thing for families to know that have a disabled loved one, if you're receiving SSDI, after 2 years, that person is then eligible for Medicare. Remember that program that many of us might be on already, but it's 65 and older? Well, younger people can get it if they're on SSDI for 2 years. There are some exceptions, a very narrow list of exceptions, kidney disorder. I don't want to misstate them, but just know that there's a small list of conditions that do not require you to be on it for 2 years before you're eligible for the benefits. Think in terms of things that will take you fast, and you need those benefits sooner. In that case, you can receive it in less than 2 years, but most people it's 2 years. And then know that there is a Social Security childhood disability benefit that is for people who haven't worked but became disabled before the age of 22, and their parent has either retired or died. They may be eligible for their parent's benefit even without having paid in their 40 quarters, without receiving SSI. So this is another category of benefit that is more along the lines of SSDI. because it's entitlement. We don't care how much in the way of income or assets that child has, but there's rules. Again, that disability before age 22 is a big one, and not everybody meets that condition. If there's a later accident or something like that that causes the disability, they may not be eligible. But if you see somebody with SSI who's never worked, SSDI who's never worked, oftentimes it's because they're on the Childhood Disability Benefit Program. Okay. I'll skip Medicare benefits, but just know that it covers a lot of our healthcare costs, but not everything. I'm sure a lot of you know that the hard way. So going back to the questions we've already gotten, what do we do if we come into money, either from inheritance or a settlement or some other way? How can we do that in the best way to preserve the benefits, the public benefits that our child or a grandchild or our family member have without losing those, but also while allowing them to reap the benefits of and have the enjoyment of that inheritance or that money that's come in? And the answer is, broadly put, special needs planning. This is an underutilized, unknown to a great degree, and I'm hoping every one of you comes out of this today and starts talking to people about it. I've done presentations for 10 years here in California now on this topic. Some of you may, the law library in Ventura, all sorts of places. I teach other attorneys about it because I want to speak about these issues and make sure people know what options they have. So special needs trusts are the primary vehicle, but there are so many different kinds. And so I just want to show you the 4 main categories of special needs trusts. And it's on this chart here. And I'm going to put this chart up a few times. So don't worry if you don't get it all, but I just want to say that the main categories we look at are third party and first party. All right, third party and first party. The main difference between those is the first column, the source of funds. Third party special needs trusts are funded with other people's money. Mom and dad, grandma and grandpa, aunts and uncles. Someone else is giving that money to a disabled beneficiary. It was never theirs to begin with. First party special needs trusts are funded with the beneficiaries, the disabled beneficiaries' own funds. So how does that happen? I'll have a slide on this in a minute, but think in terms of a settlement, like you said, Kevin, money that comes to them that doesn't pass through another family member, okay? Or an inheritance that's not properly planned for because the person who died didn't do the third-party planning. And again, I hope a big reason a lot of you are here is to know that there's an option. There is a way to avoid some of the unintended consequences by proper estate planning using a third-party special needs trust. And I want to point out one other square in this right now, and that is who gets the money when the beneficiary dies. And look for the first party, the difference between first and third party. The third-party money, the money that came, was never theirs to begin with. It was left to them by mom or dad or grandma or grandpa. It's whoever the grantor of the money wants it to go to. That's who gets it when the beneficiary dies. So we say if the beneficiary goes and there's money left, give it to his brothers and sisters or give it to these other family members. The first party special needs trust, the kind of special needs trust we have to do with money that went right to the individual, has to go first to pay back Medi-Cal, the state Medicaid program, for whatever they've paid for you during your lifetime, from the very first moment they started paying. All right, so let's talk about third-party special needs trusts, because these are my favorite, and these are the ones I hope we all start talking to people about. Anybody in our friends or if you belong to any disability support groups, make sure other people know about this. That's the best option, but it requires planning ahead, okay? So a third-party trust requires, so this is a kind of trust where you can say, when I die, do this with my money. And it requires these things. It requires that the beneficiary, the disabled person, didn't create the trust, okay? It requires that the beneficiary is not the trustee. It cannot hold the beneficiary's own money. And the trustee, the person managing the trust must have sufficient discretion and not be beholden to the beneficiary. They can't just be a yes man, a straw man for the beneficiary, just doing whatever the beneficiary wants. They truly have to exercise their own discretion. Otherwise, the government has the right to disregard the trust and say, this is really the beneficiary's own money. So you have to put those safeguards in place in the trust. All right? You can do much more in a third-party trust, though. I have families with kids with autism and whatnot, and they've come to me, and we've done these trusts that we talk about what we want basically hopes and dreams stuff about their ability to live independently and, have a care structure, a support structure in place. Because while we're alive, parents of a disabled child are that support structure. They are that special needs trust. But they're worried, reasonably worried, about what happens when I die. What's going to happen at that point? And that's where a well-drafted third-party special needs trust, it handles not just the money and keeping them eligible for their benefits, but it also handles much more, where you can say all the things you want and do not want for your child or your grandchild. Okay? The Social Security Administration says that a third-party trust must be a trust established by someone other than the beneficiary as grantor. And then a grantor is the person who provides the money. It's very simple, okay? But again, we look at these additional requirements and we want to make sure it's done properly and that nobody's going to ask questions or pick away at it later, okay? Under the federal rules, we also want to make sure the beneficiary has no authority to revoke the trust. And again, there's a common theme here, but the beneficiary cannot direct the use of the trust assets. The trustee, who is a separate person, can do that, okay? So in some sense, this seems very straightforward, very reasonable, but again, I cannot stress enough the need to do it right. And if, for instance, your trust says provide for the living expenses and the food and shelter expenses, and this is a common way trusts are written. They say for the health, the education, the maintenance, and support of my beneficiaries. We call that HEMS, H-E-M-S. Well, we've just blown up SSI, because what's SSI for? Support. It's for food and shelter. So if you don't say it right, if you don't really target your third-party special needs trust, you can create a situation where the government says, well, you don't need these benefits. You've got another way to pay for it. So it has to be done correctly. But the key thing with a third-party special needs trust, you don't have to pay the state Medicaid office back. In our state, it's Medi-Cal. You do not have to pay them back with whatever's left in the trust at the end of the life of the beneficiary. A third-party special needs trust may be revocable. It doesn't have to be one and done and irrevocable. You can make changes to it over your lifetime. Many people incorporate a third-party special needs trust into their living trust. How many of us have a living trust right now? Okay. People with disabled children or grandchildren often add a section, an article to that trust that says, for people who are on state benefit or on SSI, follow these rules, and they add that into the trust. So, and they can make changes to it anytime they want. That's okay. So there's a lot of flexibility as long as you use the correct distribution standards, the rules that we just talked about. There is one kind of unique thing, it comes up from time to time. If you're trying to create a special needs trust for your spouse, you cannot use a living trust to do it. You have to do it through a will and have a court establish it. It's a nuance in the federal law that must be a court-established trust. And I've seen it a couple of times where a spouse wanted to leave a special needs trust for the benefit of their surviving spouse who is disabled. It's not common, but when it does come up, it has to be done the right way. So you just have to know what the rules are. So by contrast, we have first party. So again, pop quiz, who can tell me what a first party special needs trust is?
And you as a parent have a special needs trust for a child who's disabled.
That's a third party. The difference with first party is the money belongs to the person who's the disabled beneficiary. So we've just been talking about, the answer was when you as a parent, have a trust for a disabled child, and that's a third party because it's your money, not theirs. So third party money going into it. That's when you have all that flexibility. That's okay. That's good. That's why I wanted to test you. So, and the fact is this is not intuitive. This is not easy stuff. So stick with me. But a first party special needs trust is the kind of special needs trust we do when the parent has never owned the money, or the parent dies and it's just left outright to Johnny and Susie, and Johnny is on SSI. In that case, they receive the money, it's theirs now. And so we have to look at first party special needs trust. And the biggest distinction, other than where the money came from, is the payback. The first party has the payback. So it's the disabled individual's own funds that are placed into the trust. And this is a kind of special needs trust that's set up under statute. This is federal law. And so you'll sometimes hear it referred to as what's called a D4A trust. That's kind of the nerdy term for it, but you'll often hear this. A D4A trust is a payback trust. That's a trust, a first party special needs trust with that payback provision. And so it comes under federal law. It's 42 USC, anyway, email me and I can give you the exact site. But if you see a D4A trust, that's what we're talking about, the trust that pays back. There are some other rules for D4A trusts that make them impossible for some beneficiaries to use. And so there's an alternative called a D4C trust, which shows up just a couple of sentences later in the federal law, where this is what we call a pooled trust. It's a charity that runs a special needs trust. The money goes to the charity instead of to the individual, and the charity manages it for the beneficiary. And I'll talk about pros and cons in a minute if we have enough time. But the key is that that's another option. Sometimes you'll see that. So if we go to this chart again, at the very bottom row, you can see the pooled trust. And the key difference is you cannot do a first party special needs trust for someone who's over age 65. A lot of these rules, I just shake my head and I say, don't ask me why they exist. They just exist and we have to follow them. They've been around. This is part of federal law. I can't give you a reason why 65 is the cutoff. I have hustled the week before someone turned 65 to do a trust for them and get it funded very quickly because they were worried about this. But if you're over 65, your only option, and you come into money, and you want to stay on your SSI, you want to keep your Medi-Cal benefits, the only way to do that is through a pooled trust. Okay, and these are nonprofits. And there's really one very unique and interesting difference between the pooled trust and the Medi-Cal Payback Trust, the D4A trust, and that is that the pooled trust, the charity can keep the money. You can elect for them to keep the money so that they can keep doing the good work that they do. There's a handful of these pooled trusts in California, and I'm aware of really good things that these trusts do, that they're helping people who are older that come into the money, and they are allowed to keep the money. But again, it doesn't go to family. It stays with either the charity or it gets paid back to the state. So it's not a great option if you prefer to have money go to your family members, your other family members. What I really, really want to avoid, and what the tragic situation that comes to my office fairly often, is that a parent doesn't know about this and just leaves money as an inheritance outright to the disabled child, and then they have no other option but to do a D4A trust, and a first party special needs trust, and it gets paid back to the state. The other siblings don't get it. Whatever's left when that person dies. The other situation that I see is the parents are aware of an issue. They are worried about the public benefits, so they disinherit the disabled child. So there's 3 kids, Johnny, Susie, and Sally, and Johnny's disabled, and so they leave everything to Susie and Sally and say, take care of your brother. I see that, and that's very common. And you might say, well, Susie and Sally are great sisters, and of course they will do this and want to do this, but they have their own problems. They have their own creditors. They may have disabled children of their own. It puts them in a very tough position to just ask them to do that. So those are the 2 kind of extreme examples of people who don't understand that there's a third way here with that third party special needs trust. So we've touched on this, but first party special needs trusts are most commonly used when there's a personal injury award. So somebody's in an accident, they're driving down the 101 and they get hit. They're in their 40s or their 50s. Well, what options do they have? they get a settlement, they're disabled now, a first-party special needs trust. That may be the only option. Inheritance or gift where there wasn't proper planning, so there was no third-party special needs trust. A minor with a disability turns 18 and has money, and then an adult who's been recently disabled, similar to that personal injury award, will sometimes need to use a first-party special needs trust. So there's requirements. We've talked about the third-party special needs trust, but there's requirements for the first-party special needs trust as well. It has to be irrevocable. It can be established by a parent, a grandparent, or the court, or a conservator. And just recently, the law changed. I would say just recently. It was a few years back now. I think in 2016, the law changed to make it a disabled beneficiary with capacity. So somebody who has capacity but is disabled can set up their own first-party special needs trust. So in this case, someone who maybe has a physical injury, but their capacity is there, they can set up their own first-party special needs trust. I've done this for a number of disabled beneficiaries that become adults and they have a disability, but it doesn't impact their cognitive abilities, and so they're able to set up their own first-party special needs trust. It has to be for the sole benefit of the person with the disability. It has to be for their sole benefit. And it has to provide that the trustee at the death of the beneficiary pays Medi-Cal in California, or whatever state Medicaid agency there is, back for all benefits received during the lifetime of the beneficiary, their entire lifetime. I'll just point out that there's some pros and cons to, if you're in a first-party situation, there's pros and cons to having a first-party trust versus a pooled trust, okay? You have control over who the trustee is, and you have control over what the trustee can do when you write that trust as opposed to a pooled trust, okay? So that's pros. More personalized attention. You can choose who your trustee is, and they're gonna be just using that money for your benefit. There's some rules as far as what types of assets pooled trusts can receive, okay? They mostly want to receive cash and stocks and things like that. They don't necessarily want to be dealing with real estate. So first-party trust, special needs trust, a D4A trust, there's more flexibility on the assets that can be held in that trust. And then, like I just mentioned, they can now be established by a disabled individual who has capacity. So again, the rules used to be that it had to be a parent, a grandparent, or the court, or a court-appointed person to set it up. I remember when I first started out practicing, a young man came to the office and said, I have an inheritance and I need to set up a first-party special needs trust. And at the time, that rule had not changed yet. And he said his parents were gone. He had inherited this money from his from his mother or his father, and both his parents were gone. And we were about to say, well, you know, we're going to have to go to court to do this. It's very frustrating, but I'm sorry that there's no. We want to see this change happen, but it hasn't happened yet. So you can't set up your own first-party special needs trust. And he said, well, what about my grandmother? Well, it turned out he had a 100-year-old grandmother up in Whidbey Island, Washington, who we got her on the phone and she said, of course, I'd be happy to. And she sets up the first-party special needs trust for this young man. So there were always ways that you could kind of work around it if you're a parent or grandparent, but now it's a very good change that we have that allows that the disabled beneficiary themselves with capacity can do this. All right? And the cons, we've touched on those already, but a big one is that if you're over 65, it's just simply not an option. Oftentimes, it ends up needing the probate court's involvement. Again, in the situation I mentioned a few minutes ago, with a young child where there was a settlement, the court is the one that establishes that trust. And so the court is involved every year or 2 years for accountings. Attorneys have to be involved. It can be very expensive. So again, there's good reasons to avoid this if possible. D4C trusts, just mention again the pooled trust requirements. They're irrevocable. They're established and managed by nonprofits. They can be funded by an individual, parent, grandparent, or legal guardian, or the court. And that bottom bullet point is the linchpin of the difference there. Instead of automatically going to pay back Medicaid, or Medi-Cal in California, it can be retained. Whatever money's left at the end of the lifetime can be retained by the pooled trust. A lot of people more recently have heard of something called ABLE accounts. Raise your hand if you've heard of an ABLE account, okay? Usually more people raise their hands, but that's good. I want to bring this to your attention. ABLE is an acronym. It stands for Achieving a Better Life Experience. And our federal legislators love their acronyms. So ABLE accounts came about in, I think, 2014 originally. And then the Enabling Act in California was signed by Jerry Brown in 2015. But they really only got up and running in California in about 2017. ABLE accounts are a way that somebody who was disabled before age 26 can keep some money in excess of the $2,000 that I mentioned earlier. This is a new thing, and they can keep more money in a special account. This appears in federal law right after the 529 education accounts. This is section 529A of the Internal Revenue Code. And so similar to the education accounts, there's limits on how much that can go in, and there's limits on what that money can be used for. But if someone is disabled before age 26, they can receive in that account a maximum of $18,000 total from all sources, aggregate, per year, all right? They can also contribute up to, I don't know why this number is what it is, but it's $14,580 of their own earned income. So somebody has an ABLE account could conceivably put in, I think it's $32,580 into their own ABLE account. And up to $100,000 can be kept in that account without impacting SSI. So because of these limits, this is not an alternative to special needs trusts, because most special needs trusts involve more than $18,000. But it can be a good sidecar to a special needs trust to give additional autonomy. That's what that bottom section, a lot of special needs trustees now are empowered to open an ABLE account and to put money in that account every year to give more autonomy to the beneficiary, if appropriate. So they get to have more walking around money than that $2,000. What are the things that an ABLE account can be used for? Here's a non-exhaustive list, right? They can be used for their housing, their healthcare needs, assistive technology, transportation, legal fees, of course, because attorneys wrote the statute. But if you think about it, they often need legal advice on what they can do and not do and all of that, so they can pay their attorneys out of it. Financial management fees. There's a whole list. If you go to the CalABLE website on our state website, it'll bring up the rules, all the application, the whole process for a California resident to establish an ABLE account. So ABLE accounts, again, are not an alternative in almost every case to a special needs trust, but they're a good thing to have in addition. And a beautiful thing is that you can set one up immediately. If you have a disabled family member, you can set it up now and you can start funding it and giving them that autonomy to then make some decisions on their own as far as what they spend it on. The $100,000 that I mentioned is important, though, because under current law, and this may change at some point, but under current law, it will impact their SSI eligibility if they save up more than $100,000. So it really is not a good option for large amounts of savings. It will not impact their CalFresh and their SSI, and their Medi-Cal if they go over that $100,000. But if they're on SSI, they'll want to keep it at or below $100,000. Okay. So the last part of the time before we take some questions is I want to address avoiding common mistakes during special needs planning and administration. So if you have a special needs trust, some of these mistakes are in the administration of those trusts. So a few that come to mind: disinheriting disabled heirs or causing your beneficiaries to lose SSI and Medi-Cal. I like to say just being here today is the first step to that, to avoiding this mistake, okay? But there's no need to leave a disabled beneficiary out of your estate plan if you wish to provide for them, and there's no need to cause them to lose their benefits by leaving them some money. So those are those two extremes, and there's a middle way, the third way, which is conveniently called a third-party special needs trust. All right? Every estate plan should at least consider the possible disabled beneficiaries that might come into your money and have some language in there that addresses that possibility. Every trust that I create has language, even if we don't do a special needs trust within the trust, we'll put language in there about encouraging the trustee to go do that if it's appropriate. That's what I just mentioned. The contingent language can open the door to later modification by a court. Okay? Another mistake, common mistake, is failing to keep informed about changes in the law. So if you're going to do this, if you're looking into this for yourself, make sure you work with an attorney that understands the rules. We've touched on a ton of rules today, and there's many more little nuances, little buts and wherefores that we need to understand and how it might impact your particular situation. Two organizations that are well known and regarded for training attorneys and giving them the resources for information about this are the Academy of Special Needs Planners and the National Academy of Elder Law Attorneys, NAELA, which I'm a member of. So asking the attorney that you're working with if they're a member of these organizations and if they really understand these rules is very important. There are many nonprofits that are specific to a particular disability. I speak commonly for the Alzheimer's Association, the ALS Society. There are, for every diagnosed condition, there's usually a support group or an organization that helps act as a resource to people with that condition. And so availing yourself of that, learning more about, because they have resources within the organization to educate members about the changes in the law so that you stay abreast of these things. And then be aware of government agencies assisting persons with disabilities. Just be aware of all of the options that are out there. There are many that do that, okay? And we have this would be a good opportunity to plug the Brain Injury Center, I believe, right? So here's a Camarillo Healthcare District, is in many ways, I guess a quasi-government entity here.
We are a public agency, a special healthcare district.
Special healthcare district. I always say that wrong, so thank you, Blair. So, and there's a brain injury center here that's very active. There's so many resources here within this organization to help people with those types of disabilities to get more information and to learn about the options that are available. Another mistake that's commonly made is confusing different types of special needs trusts. So again, this is very common. If somebody says to you, I have a special needs trust, a fair follow-up question is it first party or third party? So that you understand at least first party, that's going to have a payback. Third party, that money can go to whomever the parents or grandparents want it to go to when the beneficiary dies. A lot of times people have both. Maybe they came into some money through a settlement and then their parents also leave the money through their own trust. So they have a first party and a third party. Not mixing those two and understanding which one to pay from is very important. So understanding these things. Just a general question. This is a common sense one. If you have both a third party and a first party trust, which one would you want to see depleted first? The one that has the money going back to the state, probably, right? That's the first party trust. That's not an one size fits all rule. There may be reasons not to, but as a general rule, we think of, okay, we're going to deplete the first party special needs trust first. Distributing cash out of the trust to a beneficiary is a big mistake that happens in the administration all the time. Remember the rules, that first $20 is disregarded, but if we give cash out of the trust, it's the same as just handing them cash from some other source, and they potentially lose their benefits as a result. So even gift cards are risky. They're possible, but risky. And so you have to understand the rules and be talking with advisors, attorneys to understand this and whatnot so that you can know what options are available, okay? Confusing the public benefits programs, which we've talked about a lot at the beginning. So I won't burden you with those, but there's the quick list. And then just incomplete and improper planning, okay? So just knowing what options you have. In the case of third-party trusts, being able to do more than just say, hold the money back and give it to the sibling when the person dies, but also we talked earlier about setting up care plans for these individuals, saying use a care manager, don't place them in a group home, whatever the case, all of these rules that people can do if they want to with the third-party special needs trust. So understanding that it's not just about public benefits with third-party planning. There's much more that parents can and often want to do. All right? One option there at the bottom is including a memorandum of intent by the client. So you can actually put in there, and this is a nice thing that sometimes we attach as an exhibit to the third-party trust so that the parents can update it on their own from time to time and just put in there as much information about their child as they want, so that whoever's managing it later has the ability to read that and understand it and learn from the parent's experience and just do a better job for the beneficiary. Poor distribution process by the trustee. And again, these are mistakes that are made during the distribution. The one thing I would just say is pick a trustee that you trust, that is competent, who can figure out the rules, okay? The number one complaint that special needs trust beneficiaries have is that the trustee fails to timely respond to distribution requests. So I'll get calls from a beneficiary who are upset because their trustee isn't doing their job. Sometimes we have to go to court to get that fixed. So having trustees that you trust that are competent to do the job that you're asking them to do. Refusing to make appropriate distributions out of a trust to a beneficiary. And here's a list of things that can be done with special needs trusts under the law. You can pay for a vacation for the beneficiary. You can pay, the point is that trust can be used for the enjoyment. It's, they should be able to enjoy that money that's been left to them somehow. But keep in mind the bottom there, what if food and shelter costs are paid out of the trust? Then we know that we have an impact on SSI, right? That in-kind support and maintenance that we talked about earlier. And then not maintaining good records. Oftentimes the Social Security Administration will write a letter to a special needs trustee and say, we want to know more about this trust. Send us all the bank statements. Send us all your records. And I've heard of, didn't happen in my practice, but one office wanted 25 years, going back 25 years for records, right?
Is that legal?
Well, if they're the ones holding the checkbook and saying we need this to know that everything was done right, there's your definition of legality. I guess you could fight it in court. Again, it wasn't my case. I just heard about the request. The point is that a trustee who maintains the records and keeps track is in a good position when that request comes. I have a pending request right now for a special needs trust that was established about 2 years ago, and the Social Security Administration is asking for the records. They're going to get 2 years of statements, and they're entitled to ask for that. I think generally they want to see the trust itself, and they want to see the bank statements. So this last slide is to give you hope, though, because we're not supposed to do it on our own, all right? I'm here. There's some good resources. These books, especially the one on the left there, it's hard to read, but it says Administering the California Special Needs Trust. That's the 3rd edition. I have a stack of those in my office. I give them to every trustee that comes to my office of a special needs trust. That's by a fellow named Kevin Urbach. He practices out of the Bay Area, and he is just a whiz when it comes to understanding and advising people on this area of law. So I tell them, read this, look at it, and check that first. Give me a call if you still have questions, but at least take a look at what's in that book as a first line of defense. And then this is Special Needs Alliance has a publication. This is last year's edition. This is more national. So is this book here. That's the latest edition of that book. Again, it's written from a national perspective. What I like about Kevin's book here is that it's California specific. So it has a lot of Urbach, Urbatsch. Just email me on my card and I can send you a link to it on Amazon. So, yes, sir.
Are trustees entitled to compensation?
Are trustees entitled to compensation? The answer is yes. Yeah, absolutely. We got rid of slavery with the 13th Amendment, so we don't have to do that anymore. Absolutely. If you put time in there helping somebody, part of the deal is you're entitled to be paid for that time. What the compensation is, if that was your follow-up question, is whatever's reasonable at the time, which varies by geographic location and when it's happening. So we don't put a dollar amount, we just say reasonable compensation. That's a great question. Any other questions? I blew through this stuff, and I just want to make sure I got 5 more minutes. Yes, sir.
You mentioned that there were certain things that, if you, that were against the special needs person, you wanted to give them this amount of money after you sold some of the items or things that you mentioned. If you give it to the trustee, are they still going to control that money? If the special needs person says, well, that was my dad's money, he gave it to me under the trust, but then it was like a car. You said something about automobile. That wasn't,
So I think what you were asking about is there's exempt assets.
yeah.
So everybody on public benefits, SSI and Medi-Cal, can have certain assets that are exempt. A home, a car, personal items.
The car's worth $100,000
Uh-huh.
and it's put into a trust.
Sure. So who manages at that point? Yeah. Well, that's a great question. And I heard somebody kind of gasp at the 100,000, but the fact is there are a lot of vans that have the wheelchair lifts and whatnot, and they're easily $100,000 vans. So you're not off by using that figure. And the answer is it can either be owned by the beneficiary. They're allowed to have one vehicle, so that can be their vehicle. Or if they need more than one, or if for practical reasons it makes more sense, it can be owned by the trust. Either is an option. And there's practical reasons why you may want one over the other. And I won't get too far into that, but just, for example, liability. If it's owned by the trust, there may be liability that the trust then carries if there was an accident or something like that. It might actually be better for the beneficiary to own it, and they're allowed to own it, so that's okay. So the question is, can a beneficiary tell a trustee they want a lump sum of money that was put in the trust? The answer is not if the trust is written properly. That's the key with both of these, a first party or a third party trust. Once the money's in there, the beneficiary has no control. So even if it's a first party trust and they set up the trust themselves in order to maintain their public benefits, and they put the money, they write a check or they transfer the money into that first party trust, it's now controlled by their trustee and they can't get it back. And that's a big thing that a lot of people have to think about. Is this a good idea? So let me give you an example from a purely practical perspective. If someone comes into money, remember a house is exempt. So if they're living in an apartment, they don't own a home, and they come into money, we're going to have a discussion when they come to my office about whether to set up a first party special needs trust or perhaps to just set up a regular living trust and buy a home with that, because that home is exempt, right? So they can have a home, and maybe we don't put the first party special needs trust together, because what's the difference? What's the thing about the first party? Everybody should have it at the tip of their tongues now. That money, when they die, goes to pay back Medi-Cal. But if they have a home, they can just set up their own living trust and leave it to their siblings or their kids or their neighbors, or if they're married, their spouse, they can leave it to whomever they want. So there's a lot of nuances and a lot of planning that you have to do. It's not just automatic now when someone comes into an inheritance, just put them in a special needs trust. It's not, or a first party special needs trust. We have to think very carefully about whether and to what extent we use a first party special needs trust because of that payback. Because it goes, and I've seen 6-figure, $200,000-$300,000 claims made by Medi-Cal when someone dies. I have one right now that's about $230,000 for a trust that has about $75,000 or $70,000 left in it. So Medi-Cal's not going to get $200,000, but they're going to get close to $70,000 when we're done. So this is a real consideration, and we think about these things as part of the planning. I think the number one takeaway is that there's a lot of rules, but there's some good options, and they should talk. you should talk with, or the beneficiary, whoever it is that needs to make the decision should talk with somebody who understands the options. And again, I'm happy to be that resource. There's a no-charge complimentary consult for anybody that comes and talks to me about it before we do any work, just to talk about the options. We're happy to have that discussion with you. But any attorney you speak with, ask them if they really know this stuff and are they trained in it, so that you can make sure they're going to avoid some of these mistakes. Okay? Yeah.
If you have a trust and you are the person that's in charge of it, and the disabled person cannot have a driver's license, can you buy a car to get them around or a part of it? Because can you take money out of their account to do that? Is that part of one of the things that I saw automobile, but it's kind of like.
I think I got the question. Let me repeat it back, and I think you'll like the answer. The question was, we know that one vehicle is exempt. Can that vehicle be purchased for somebody, even a disabled beneficiary, even if they're not able to drive? And the answer is yes. So separate from the trust, remember, these are things that person can own. So the disabled beneficiary who's on SSI, who's on Medi-Cal, can own a car. But that car may never be driven by them if they can't drive. That's okay.
In their name.
In their names, yeah.
No lien holder or anything like that.
Right. So say they come into,
Driver's license, and it has to be.
say somebody comes into $50,000, okay? Just doing some quick math. How much can we put into an ABLE account? 18,000. Okay, that leaves us 32,000 left. Go buy a car. And now we're done. No special needs trust needed in that case.
I have a special needs trust, but it probably needs to be reviewed because it's 22 years old.
Okay.
But my question would be, it's my daughter's in charge
Okay.
for my son.
Okay.
And if he would die, would his inheritance go back to her?
Okay.
Do I need to put that in?
Yeah. So the question was, this person has a special needs trust, a third-party special needs trust established for your son with your daughter as the trustee. And the question is, what happens when your son dies? I hope that the attorney did it right and that it says I leave anything left to my daughter. That's the whole benefit of having the planning ahead that you did. But we'd have to take a look at the trust and make sure that's what happens. The other thing is you want to make sure you have backup trustees. So you might want to take a look at that because we don't know who goes first. If anything we've learned in the last 4 years, it's that life is unpredictable. So have backups no matter what. But if the attorney did things correctly on your third-party special needs trust, there should be no language about paying back the state because that was never your son's money to begin with. That's the key difference.
I have a situation. I live in California. My mother and brother live in Phoenix, Arizona. My mother took out a special needs trust for both my brother and I. I have a history of disability. He does too. So now my mother has passed away, and her trust should be engaged. But whoever we named to distribute the monies declined to do it. So I wonder if you have any suggestions for, of course, what to do next.
Sure. The question was, what if we have a trust, a special needs trust, or this would apply to any trust, where this named successor trustee declines to act? And the answer is, whatever the trust says in that situation controls. Sometimes it says the beneficiaries elect someone. Sometimes it says, it shouldn't say that for a special needs trust. It should have another name in there. And if it doesn't have another name, you have to go to court and get somebody appointed. Yeah, you have to do that. Otherwise, there's no way to administer it. No bank will work with someone unless they have authority to do that. So it's a tough spot. It's why, in answer to your question, I said name backups. Have multiple people named, because it's very important to not get in that situation if we can avoid it. Well, thank you all for coming. I said there'd be a pop quiz about my wife's name. You can reach me at 246-SARAH. Feel free to give a call anytime if you want to set a follow-up appointment, and we can take a look at what you have or discuss options for you and your family. I'm happy to do that. Thank you, guys.